جی 9019
مالوٹ
19 ہے.
It's Mudassir Hassan Jura. Lord, I have also submitted the submissions. It is CMA 8300, and there is another booklet that I was able to prepare today that I would be submitting during the course of the arguments.
ایک مل گیا 19 نکلوا دیں. جی
My Lord, I would, Your Lordship, the case law is very well known. I would not go into the case law details I have mentioned in my arguments, but I would touch upon the broad-based thing, and I'm grateful to Your Lordship in saying that we have to go by the letter of the Constitution. The Constitution is very clear. I am confident that I may be able to convince Your Lordships that by reading the Constitution itself, we may be able to find an answer whether this is a valid law or it is not a valid law. So in essence, Your Lordship, the question that was asked is about legislative competence. Now, legislative competence has two parts, and in fact, in the
we haven't asked you any question.
My Lord?
We
No,
haven't
my Lord,
asked.
to the previous counsel.
Go leave it for them. You argue your case as
My
you
Lord,
want to.
this is a legal question that I would say. It has a process whether there is a legislative competence, and even if they have the legislative competence, whether the contents of the legislation are within the framework of the Constitution. And then the third question, of course, in the light of the provisions of Article 191 would apply, because 191, and I would like to read those provisions also, does not places a further requirement that even if a law is passed, Your Lordships have to implement that law, because it says, subject to Constitution and law, the Supreme Court may make the rules. So that is something I believe is, which is something which is missing in the Constitution. However, Your Lordship, first of all, the maintainability questions, very briefly, there are 3 points which are relevant for maintainability. The first is that it touches upon the judicial functioning of the Honorable Supreme Court. Now, judiciary is one of the 3 pillars of the Constitution or the state, and therefore, if we go by mathematics, it covers around 33%, if not more. So that is a very substantial question.
Please make some legal arguments.
My Lord, that is...
No, please, आगे बढ़िए ना. 33%, what sort of argument is
My Lord,
this?
because it touches upon one of the pillars of the Constitution.
आगे बढ़िए,
And
please.
if it's a fact, that pillar, then
आगे
it affects.
बढ़िए.
My Lord, the second point is, of course, if Your Lordship may see Article 50, if I may...
50?
50, my Lord. And these points, my Lord, I'm trying to show to Your Lordship that there is a very serious questions which are to be considered. 50 defines the Majlis Shura.
Can you tell us what point you're making before we start reading something at
My Lord,
random?
this is on the maintainability of the petition. There shall be a Majlis Shura, Parliament of Pakistan consisting of President and 2 houses to be known respectively as the National Assembly and the Senate. Now, my Lord, the submission is that this bill was sent to the President for assenting. The President, as a part of the Parliament, raised an objection to this thing, and there was a press release. The President...
Please argue your petition.
My Lord, that is...
Which ground is this?
My Lord, that is...
Where have you stated this in your petition?
My Lord, on the legislative competence, if you...
Where have you stated all these things?
Lord, this is an
ये हुआ, President did this.
This is an elaboration of my arguments that Your
No,
Lordship...
no, you cannot argue something factual which we don't know about.
Lord, this is, I have a paper book that Your Lordship I would be submitting now, because there was a press release, and this is...
फिर आप आ गए press release पे.
My Lord, I would, if Your Lordship is not convinced on that, I would say...
I mean, it's not a question of convince. I don't think it's any sort of argument.
My Lord, the reason why I'm submitting this is that even within the Parliament itself, there is a dispute whether this law could be passed by the parliament, because the presidential...
Suppose we agree or disagree, what difference will it make?
My lord, because it would give your lordship the thing that this is a very serious matter which has to be considered by your lordship, because the parliament itself is debating and discussing whether they have the legislative power or not. And president is the head of the federation. So when the president is saying, and part of...
He told you. He told you.
My lord, it is part of the record, my lord.
No, which record?
My lord,
Before us?
The press release issued by, my lord, this is...
No, before us, which page is it?
My lord, both...
If he's told you something privately, well, that's good for you.
My lord, this is the paper book that I have prepared.
اب آپ بتائیں نا, ریکارڈ پہ رکھیے, بتائیں نا. یہ آپ نہیں, ہم کچھ نہیں لیں گے آپ سے, ایسے اٹھا کر کے کاغذ آپ دے رہے ہیں, یہ کوئی طریقہ نہیں ہے فائلنگ کرنے کا.
ملٹ یہ ابھی
نہیں, ہم نہیں لیں گے, سوری, یہ بالکل جو مرضی. آپ اگر کوئی لیگل آرگومنٹ دے رہے ہیں, کوئی بک سے کاپی دے رہے ہیں, جیسے چودھری صاحب سے سیکھیے, انہوں نے بکس کا حوالہ دیا جو انہوں نے منجمد کر دی.
میں نے 3.8...
عرفان صاحب پلیز آرگیو دا کیس.
ملٹ I would go to 184.
جی.
And my lord, the relevant grounds I have mentioned, they are starting on 184, is starting from page 8 of the paper book, the submissions that I have made. Your lordship, if with your permission, I would start the wordings of 1843, my lord. My lord, the relevant part is, without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights referred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article. Doctor, the legal submission is that this provision of 1843 is not beginning with subject to Constitution or subject to the law. This is an open-ended, wide provision which, even when we compare it with Article 199, 199 is subject to the Constitution and it permits only an aggrieved person to bring out a petition. Whereas 1843 does not places any restriction that a person who comes to this honorable court be an aggrieved person. And lordship, the second important point on reading 1843 is that it talks about the Supreme Court shall. This is a mandatory requirement that it is the Supreme Court by itself. Whereas the legislation that we have challenged has provided for a committee to decide whether they are. So, in essence, what the law is doing, the law is replacing as a first step the Honorable Supreme Court's function and transferring it to a committee which may not even be considered as a judicial function. That would be an administrative function. And the third condition of 1843 or the power...
Are you, just clarify this, are you contending that individually Chief Justice of the Supreme Court cannot invoke this power and this power vests exclusively in the Supreme Court, which means the Chief Justice and all the judges of the Supreme Court? Please clarify this.
My lord,
what are you saying?
My lord, that to that, my lord, 191 gave the power of...
جواب دے رہے, اب دوسری طرف آپ چلے جا رہے ہیں.
My lord, no, my lord, I'm coming to that question because that is relevant. In the context, it's relevant. My lord, the power was to the Supreme Court. The Honorable Supreme Court sat down, they made the rules. And all the judges, the Supreme Court, then delegated their own power as a whole to the Honorable Chief Justice through the rules. So that is...
کہاں لکھی ہے یہ بات?
My lord, that is in the rules, my lord.
Whether the Supreme Court can grant the power assigned to the Supreme Court in the Constitution to someone in the Supreme Court, say to the Chief Justice or to the senior attorney or
Lordship,
anyone? Can this be done?
That is
یہ ڈیلیگیشن آف پاور کا پڑھ
that is the delegation of power. That
کون
is
سا رول ہے؟
Article 191 empowers the Supreme Court to make rules,
my lord.
and those rules are administrative in nature,
Absolutely.
and the formation of benches is an administrative power. So is the fixation of cases.
My lord,
Now, what this law does is, notionally, it removes that power from the Chief Justice and assigns it to 2 more judges, a committee of 3 judges.
yes, my lord.
اب اس میں اگر وہ ڈیلیگیشن کا ایلیمنٹ ہے تو یس ان ایکسرسائز آف ایڈمنسٹریٹو پاورز the court can delegate some of the powers to one of the judges, be it the Chief Justice, be it a committee, be it 4 judges, be it 6 judges. That power has been exercised under Article 191, which is a constitutional mandate.
Absolutely.
So where a constitutional mandate empowers the Supreme Court to make rules, those have a certain sanctity attached to them.
My lord, we have to also see what is the constitution mandate as a whole. The constitution itself recognizes this principle of delegation of powers. Even the parliament has the parliamentary parties. The function, certain functions like the law making function is delegated to the select committees or the thing. So that also works in the company law also. That is, I think, one of the fundamental principles of law as a whole, that the powers can be delegated to another person or within that body. So that is what my submission is.
This is not a delegation of power.
میں یہ سمجھو
This is not a delegation of power. یہ تو Chief Justice along with 2 members of the bench or the Supreme Court will make the
Your Lordship,
cause list or the benches.
that it's
Chief Justice has himself not delegated any power to the other 2 judges.
Then
So this is not the case of delegation.
then the question would arise that the Supreme Court delegated the power to the Honorable Chief Justice. Now, whether this Honorable Supreme Court itself as a whole can withdraw or replace those powers, or the Parliament can do that.
Is
The
it your
Parliament cannot do
argument- Is it your argument that Article 191 does not delegate this power to the Parliament?
To the Parliament, absolutely.
In order to shield the working of the Supreme Court, Article 191 specifically says the Supreme Court would make its rules.
And my lord,
Now, what if one were to flip the argument, what prevents the Parliament from making a law to say, okay, matters relating to 184(3), formation of benches, sitting of benches, the number of judges who would sit on each bench would now onwards be determined by the Parliament.
Aye?
Would be determined by the Parliament.
My lord.
I mean, اگر
Lord,
ان کے
then
پاس اگر لیجسلیٹو کمپٹنس ہے تو وہ یہ قانون کیوں نہیں بنا سکتے؟ My question to you is that.
My lord, my answer very quick.
If I may add to that, just add to that, what if Parliament makes a law saying that all of these things which my learned colleague has specified, the power to that is delegated to the federal government?
Yes.
My lord,
There is no end to it. Then their separation of powers becomes a completely illusory concept, whereas there are innumerable judgments saying it is one of the most fundamental principles. The executive branch has been kept out. The Attorney General argued on the last date that in respect of rule-making power, previous constitutional dispensations had said rule-making power will be with the previous sanction of President, meaning executive branch. And learned Attorney General told us that in this law, the executive branch has been kept out of the rule-making power. But what is if this power vests in Parliament is the federal government banayegi rules?
my lord, if I may,
I mean, there is then no end to
there
it.
is no end to it, but if I may jump my arguments, I made them systematically.
نہیں آپ آرگیو کریں جیسے آپ کو کرنا ہے. کتنا وقت آپ لیں گے؟
My lord, if your lordship go uninterrupted, maybe half an hour. my lord.
ٹھیک ہے, ہم آپ واپس آتے ہیں.
My lord.
یہ لرنڈ کاؤنسل ایک کویسچن جو ہے وہ ذہن میں رکھیے. Again, I will reiterate, this is a law that ensures access to justice, whether it's the appeal, and also secures, promotes the internal independence of the judiciary. So is the Parliament not competent to do that?
I will answer you very.
چلیں واپسی میں آتے ہیں. ہاں
Well, یہ تو نہیں ہے نا کہ چنگا ہے تو you have to follow the rules and regulations.